All right, students, welcome to the lecture for Chapter 4 for BUL 3130. We're going to be talking about the Constitution and constitutional law. This will not be a real long lecture. It's kind of a smaller section that we're going over. We're going to touch on some basis and give you a little detail and then go on from there. All right, so let me get you set up where you can see the screen that I'll be looking at. All right. And as we think about this, keep in mind one rule of thumb when you're thinking about the Constitution and how constitutional law applies to business. Businesses are, in most cases, treated as individuals when it comes to the way courts administer the rights that businesses have in our legal system. So how we're protected by the Fourth Amendment from illegal searches and seizures, so are businesses. We have rights that protect us from, incrimination, different things on those lines. We have the right to free speech. We have, those rights. Those are all allotted to businesses with some caveats that apply specifically to businesses and how they do marketing or, communication in that sense. They can be sued for false advertising, things on those lines. So as we think about that, and when we look at what later in the term, we'll be looking at the civil cases and some of the things that can be brought against someone, and some of that will play into this. So you'll hear a couple of terms as we go through this lecture that you'll also hear as we move through the term. Let's go ahead and get started with this. All right, so we're going to cover just some basic principles of constitutional law. We'll talk about governmental powers and the limitations of government. All right, so our basic principles, we have a system of federalism within our nation. That means that we have division of power between the federal government, the U.S. government, and our state governments. And we understand that the Constitution gives powers to the federal government, but whatever powers the Constitution does not give to the legislator, to the president, they are allotted to the states. So there are a lot of things that states cover and things that states will create laws and statutes for that are not covered under the federal system because they're not a power that's allotted according to the Constitution. We do have to take in consideration, though, when there is a law that is federal and a law that is state, that the federal law will take precedence. That's the federal supremacy clause of the Constitution, that any federal law overrides state law. Now, there are several federal laws that are not followed by the states. The most blatant of those, most common, is your possession of cannabis and ways that a person can have it. We have states that have it for strictly medicinal uses. We have states that allow small quantities for recreational use. And then we have states that are, you can buy it and purchase it for recreational use in any quantity. Well, according to the federal law and federal statute, any possession of marijuana is against federal law and violates a federal statute. Well, in that instance, we do not see so much the federal supremacy clause come into effect because the federal government has chosen, for the most part, not to enforce it. Even though states have, slowly been bringing it into the legalization realm, and more states. And matter of fact, I believe there's an issue on the ballot in several states this coming election that will legalize it for recreational use. And that, once again, is something that goes completely against the federal or federal regulations on it, federal statutes. So even though we have the federal supremacy clause, it's not always enforced by the federal government, and that allows the states to have some autonomy. And that is important for states to be able to do because they need to be able to function as governments within inside a government and set up laws that meet the needs of the citizens in their state, within their state borders. Federal preemption, the doctrine that allows federal law to take precedence over or displace state law in certain areas, is part of that supremacy clause. When we think about what the supremacy clause of the U.S. Constitution is, establishes our Constitution as the supreme law. Now, we talked about this when we did the beginning of law, when we did the intro to law, that there isn't a higher law in the land than the Constitution, than our U.S. Constitution. Any law that's made must be made to follow the Constitution. The supremacy clause is in place to make sure that happens. Now, is that completely different from when we think about federal law and state law? Well, it is, because the Constitution is the overall law. That's our supreme law in the land, where federal laws are statutes that were created. So the Constitution doesn't address things such as the use of marijuana for medicinal purposes or recreational purposes. The Constitution doesn't address driver's license. The Constitution doesn't address our ability to get into a car and drive from state to state to state, or get on a plane and fly from state to state to state. There's not anything in the Constitution that puts a restriction on that. Now we have restrictions that you have to be verified in your citizenry to be able to go to these different places like that. But there is a place for the federal supremacy or the supremacy clause to take place when a law goes directly against one of our rights given to us by the Constitution. That's important because we do not want to give up our rights just to be able to have autonomy in the states. Now, it's good for the states to be able to govern themselves, but if that goes to the point where we have to give up a right that's a constitutional right, then we need the supremacy clause to be triggered so that that cannot take place, and we can have a redress when we go to court or whatever means we have to use to make sure that our rights are being protected. Go to court through the ballots, those type of legal means that we have to make sure that our rights are not being infringed upon. We have judicial review, and I'm not going to go full detail into judicial review. It has been around for most of the time that our nation has been around, but it did not come fully into effect until the change in power between the second president, John Adams, and the third president, Thomas Jefferson. When those two presidents were changing over in power, there was a emergency order that Adams sent out to have some judges and justice of the peace assigned to have seats within the judiciary. They created new judgeships so that there'd be people in place who believe the same way they did as far as political ideology, and they would be able to have those seats. One of those justices, Marbury, who was waiting upon his appointment, did not receive it because when Jefferson came in, he directed Madison, his Secretary of State, to withhold those. Madison withheld them, so they were not sent out, and Marbury sued Madison as the defendant in the case, and the court decided by using judicial review that there was some violation that happened, and the court said it is our place in the Marshall Court, and Chief Justice Marshall, in his opinion, stated that it is the place and the purpose of the court to ensure that the branches of government are not overstepping the power given to them by the Constitution, or in turn violating the Constitution in the way they treat the citizens. And that's where judicial review came in and became prominent. And when we think about how the powers of government and our branches of government work and their checks and balance system, that is where that is tied into. Separation of powers. We have the ability and within our nation to elect officials from our states who represent us in Washington and Congress. We have senators and representatives from each state that go, they create our laws and vote on our laws, and they're one part of Congress, or they're one part of the government, the legislative branch. They send it to the executive branch or the president for him to sign it in. Now, a lot of this is review. You know this stuff, so don't think this too difficult. You know this, and you understand that Congress creates the laws, votes them in, sends them to the president. The president signs it, and then the court looks at it to see what is going on with it. The powers are separated so that one person or one group doesn't have too much power. We normally have a split government where we may have a president of one party and at least one house or one chamber of the legislator being of the opposite party. Currently, we have a Democrat as president, a Democratic Senate with a very thin margin, and a Republican House with a very thin margin. That is a good way for there to be a check and balance system if everything is working the way it should. Now, it doesn't always work the way it should, but in a perfect setting, Congress would be a check and balance against the president. The president would be that against Congress, and the Supreme Court or the judicial system would be that against both by using judicial review to follow up on that. When states take action within their states, they have limits that are based upon the Constitution. Remember, supremacy clause. So they're limited to only be able to do stuff up to the point of the Constitution. The 14th Amendment and the Bill of Rights tighten down on what those rights are for the people and says what government cannot do. The Bill of Rights, as has been known for ages, the first 10 amendments, and we have the other amendments that follow. Those are our rights as far as being citizens of the U.S., and they say what government cannot do to infringe upon them. They're just as much as they are rights, they are protections against the government. We are protected from the government. And now you may think, why do we need protection from the government? Well, if we didn't have those protections, you wouldn't be able to voice your opinion about political issues. You may not be able to voice your opinion about certain things. You may not be able to worship in the way you choose to worship. You may not be able to do certain things that you do. You wouldn't have a protection against illegal search and seizure. You would be able to be tried for the same crime over and over and over until they finally got a conviction. Those type of things are the protections we're given. We're protected from double jeopardy. We're protected from illegal search and seizure. We're protected in our right to worship in the way or not worship in the way that we want to. We're protected in our speech, that we can say what we feel and state it in a way, as long as we stay within the legal means of doing so. We're not causing damage, or we're not causing harm to someone by what we're doing. We're protected in our speech to say that we don't like the president, or we don't like a representative, or we don't like a senator, we don't like a mayor, we don't like a sheriff. We're protected in what we do because we're allowed to say those things, as long as we don't use words that are inflammatory and threaten harm against those officials. There is a line from free speech to criminal activity. And once you step over that line, you can't turn around and jump back into free speech like nothing happened. So it's very important to understand that we're given those rights, but like any right that we're given, we can give it up by our actions or inaction. Businesses have those same protections. I started this off by saying that businesses have those same protections. The right to free speech. A business can come out, and several businesses do, especially during elections. You'll see where businesses and business owners will back certain political candidates. A business will put out ads or produce merchandise that shows their backing of certain issues. So they have the right to do that. They pay whatever consequences may come as far as their customers or the consumers go. And sometimes there may not be consequences, but they have the right to do that. They're protected in searches and seizures. You have to serve a search warrant on a business the same as you do on a person to search them, unless you're given permission to enter into the premises to do the search. You have to produce a search warrant to get files, to get emails, to get any type of communication that's going on, to see what's being produced, those type of things. All right, so we're protected in that. We're protected also in the states in the same way, because the 14th Amendment carries over that the states have to abide by the Constitution and the rules that the Constitution sets down, and the rights that had led up to the 14th Amendment, the states must abide by those. There's a quick diagram of how this lines up. You'll notice that the judicial system, or the judicial branch, they have judicial review against it. Both of the other branches. The executive and how it works with the judicial, they appoint federal judges. So judges that are placed, they appoint them. The legislative branch, they confirm those appointments. And that's, when we think about that, that's pretty much what the executive and legislative do as far as their level of control over the judiciary. Once those federal judges are appointed, they're there for life, unless there is an event that would cause them to be impeached from off the bench, which would be them breaking laws and doing so to the extent that they would need to be removed from the judiciary. Governmental powers, we have several of those that we need to take into consideration, especially from a business point of view. The federal commerce power is the federal government's ability to regulate trade and commerce with foreign nations and among the states. It governs the import and export policies, trade sanctions, transport of items across state lines. There's regulation in that, so they regulate interstate commerce. In other words, it goes from state to state to state, as opposed to what the states do with intrastate. The states have power over any intrastate, anything that's inside their borders. They have power over that commerce. But once it crosses lines, it becomes federal jurisdiction at that point. And so the federal government has the power over that interstate commerce. That keeps a good market flowing in the nation. It allows for businesses to conduct business without being hampered by, laws in each state that they go through, keeping them from going through that state. All right. So they have the ability to go from state to state without interstate commerce. The states can regulate what is theirs and only what is theirs. They can issue license. Normally you'll have to have a license to do business within the state. Even though something like a Walmart has their headquarters in Arkansas, for them to have stores in the state of Florida, they've had to obtain a license to operate within the state of Florida. When you go in a store, if you go to where their licenses are displayed, you'll see a license that says for the state of Florida. You'll see one for the local municipality they're in. They have done everything they need to do to be able to operate within that city or that county. And that's how they operate in those areas. But once that product is shipped from wherever it's shipped to, gets to a distribution center and goes to the store, at some point it has crossed lines. Everything you see in a Walmart store is not created in the state of Florida. Probably very little of that's created in the state of Florida. So it had to come from most likely somewhere overseas. But at some point, it made its port in the U.S. and was transferred across state lines to get to where it's at. And so that is part of interstate commerce. So we have a business, a big corporation like a Walmart, who is protected on interstate commerce, or they're under the laws of interstate commerce, plus under the laws and regulations of the states for which they work in. They have to make sure they're doing everything within the state laws to operate that store in the state. Fiscal power. This is the part that deals with, most of you being business students, you understand what fiscal powers are. But this is our money and what the federal government does with the money and what it means. They can tax and spend. All right, so they can tax us. They can spend. They can levy taxes. They're given that right by the Constitution to levy taxes or to raise taxes. And then they're given the ability, the right to spend it. It's part of the duties of the legislator to decide how they're going to spend. All right, so Congress can levy taxes and allocate government spending. That is part of the article that describes the creation and how the legislative branch is supposed to work. By doing that, they can decide that, okay, we need to increase taxes on a certain area so that we can improve infrastructure. We can improve competition with other countries. Sometimes our taxes go to increase industry within the United States. That in turn allows us to be more competitive with other countries. The most prominent thing now are chips that are being designed and created to be able to function within the needs of AI and all that AI is doing, and how much more processing it's going to take for that type of computing to take place. All right, so the creation of that and things, the Biden administration had the CHIPS Act that it set forward just for that purpose, to protect against information from U.S. businesses being taken to foreign countries, especially foreign countries that are not considered to be allies, and used for reasons that it should not be. It also was there to protect our commerce and what we're doing. So we spend money on those type of things because taxes have to be allocated for the enforcement of those things. And so they tax and then they spend it in a way that should be to the betterment of society, to the betterment of the nation. That is how they do that. So a thing like a Medicare tax, you're taxed on that so that if you get to the point where you need it at an older age, same as Social Security, those are supposed to be there for you to have when you need them, when you can no longer work, when you can no longer, provide for medical care. Those are supposed to be able to kick in. The highways we drive down, I drive up and down the turnpike several times a month, and in doing that, I drive right through construction, and they have these big signs up at each end of the construction zone that says your turnpike dollars and your taxes at work, widening the turnpike from 2 lanes on each side to, I believe it's going to be 4 lanes on each side. They're widening it to. So that's part of the money that's being done. A levy of money by the state of a turnpike that you pay when you go through. And it's like an $8 round trip, $9 round trip to go from where I am to Kissimmee and back. So that's every time I do that, they're getting that $8, and I'm one of thousands, tens of thousands on the road at any given time. And so they're making money and they're putting it to use doing that. That is taxes or money being created through a system of, putting a levy against the people, and then turn around spending it on what the people need. Better roads, more space to travel because of so much traffic that's on the turnpike. The federal government can also borrow. We have a deficit that we work within. Almost all nations work within a deficit. It's not a wholly and truly American thing. It happens in most nations, and we can coin money. So the Federal Reserve is in control of inflation, and they've been working hard over the last few years trying to get inflation under control to the point that now they're getting ready to start lowering the interest rate. They're going to start doing cuts on the interest rate this month. This month being September, the first cuts are supposed to come out, and we'll see what they do, how much they cut to lower the interest rates. But that is their role to control inflation and interest rates. They do that by regulating our money supply, saying, okay, we don't need more. Maybe we do need more. They have certain oversight over federal institutions as far as inspections and things that go into that. But we have a banking system, monetary policies, those type of things, and we have a Federal Reserve that works within the federal government to do that, independent of the president, of Congress. They work within the system to do that. The head of the Federal Reserve, they are appointed by the president, but they are meant to work outside of the president's purview. In other words, they do not make decisions based upon, or are not supposed to make decisions based upon the president's political view, but upon monetary policy, economic numbers, data, monetary policy. The last thing we're going to talk about with federal powers or powers of the government's eminent domain. Eminent domain, they need to come in and they need a piece of property. Where I live at in the local area, a few years ago, several years ago now, they began construction on a bypass. The bypass was completed. Even now, that's been completed for about 5 years. But the bypass was completed. But to do that, they had to go through private property. So the government paid a fair value for all the land they used for that bypass to the landowners. One of those landowners, their house is so close to the turnpike or to the bypass that I would not be surprised if when big semis go by, if their windows do not rattle. It is that close, but that's where they were bringing it in, and they purchased just enough of that property that they could do that. But they have the ability to do that because that is part of the federal government's purview. They can acquire private property for public projects. They have to show a just cause. It has to be something that there's no other way of doing it. And then they would give them a fair value for it. Now, what the government says is a fair value, what the market says may not be exactly the same thing, but it's still a fair value according to how they would value those sections of property. I'll let you look through this one. Just kind of breaks down the powers. You have the center part, that's all the federal powers, and then the stuff outside of that. Anything you could think of that the states do. And if it's not by the states, then it's within our power to do it. All right. Then we're going to talk about these tests real quick, and we'll get into a little bit of the information on those. But we have different tests that the courts use to decide whether or not something is working within due process the way it should. Was due process followed before the law was enacted? We have the strict scrutiny test, intermediate test, and the rational relationship test. Now, I'm not going to spend a lot of time with the chart. I want to get into talking about these. All right. The chart's actually out of place. It should be a lot more slides further. All right, so we're going to pause your thought on that. And we're going to get into the contracts clause. So contract clause, and we're going to talk about contracts later in the term for a few weeks. But right now we're going to talk about just the contract clause. It prohibits the states from enacting any law that would retroactively impair contract rights. In other words, they can't put a law in that would go back and mess up a contract that was done and the rights of the parties in that contract. It's meant to ensure agreements between private properties and anything with the government is honored. Some examples of cases that were involved, the contracts clause. One is Dartmouth College v. Woodward from 1819. The Supreme Court ruled that New Hampshire could not alter the charter of Dartmouth College because it was a contract, and the state's action violated a contract clause. A charter is a signed legal document. It is an agreement between normally the founders of a college and how it's going to work. In 1978, we have a further case, which was Allied Structural Steel Company v. Spanos. The Supreme Court struck down a Minnesota law that retroactively required employers to pay a fee based on the number of employees they had discharged. The court found that the law impaired existing contractual obligations between employers and employees. So notice these are two that are struck down because they were interfering with contracts. All right, that's what the contract clause is. Then the last one is Trustees of Dartmouth College v. Woodward, something similar. The Supreme Court invalidated that state legislation attempting to alter the governance structure of Dartmouth College. So here we had in Dartmouth College versus Woodward, the first one was Supreme Court ruling that they cannot alter the charter. And then there was another suit involving the trustees and the governance structure of Dartmouth College. It recognized the original charter as a protected contract under the contracts clause. So that ruling, so we had precedent being set here. Remember precedent from when we talked about it? So it's precedent set in Dartmouth College v. Woodward. In the case of Trustees of Dartmouth College v. Woodward, that contract being precedent, already being the court already saying that, yes, this is a valid contract and it's protected under contract clause, allow this case to be found in favor of the Trustees of Dartmouth College. The amendments and how they work. We're going to talk about a couple of those. The First Amendment's the one we're going to talk about. So corporate political speech is protected. It treats corporate political speech similar to individual speech, granting strong protection to it. The next one's commercial speech. The Constitution looks at commercial speech and it involves expression of related economic interest. That's their advertising. It doesn't get quite as much protection because we want to make sure there's truth in advertising. The regulations on commercial speech, they serve a substantial government interest. They have to directly advance that interest and be no more extensive than necessary. So any regulation passed on it has to go through one of these tests that we'll talk about here in a second. The final one is defamation. Now, defamation you can see from a business standpoint or individuals, and we'll talk about defamation a little bit more extensively when we get to torts, and because that is one of the torts we'll talk about. But defamation is a communication, and here is the trigger for defamation to happen. So they're making communication and they're talking about someone. Well, you can do that. But if it's a false statement, then it becomes defamation if it injures that person's reputation based upon your false statement. That is defamation. A business can be sued for making such a claim. Individuals can be. This is one of those times where individuals and businesses are treated the same according to the Constitution. The First Amendment protects your free speech, but does not protect against defamatory type speeches or statements that we make or that a business would make about certain things. Public figures must prove there's actual malice to win a defamation case, where private individuals, they just have to show that there's negligence involved. Why the public figures? Because if we think about political times, there's a lot of things that are false that are said about political candidates from both sides. They shoot falsehoods at each other all the time. Pretty much their goal is to defame the other person. They're purposely being defamatory toward the other person. But that is different than when it becomes an individual. An individual, we're protected from someone doing that to us. We have to prove that the other party was negligent in what they were doing. They did so knowing that there was going to be an issue there. All right, due process. We'll talk about due process real quick. All right, when we talk about what due process is, the Fifth Amendment and the 14th Amendments give us a guarantee that no individual shall be deprived of life, liberty, or property without due process of law. It protects individuals from arbitrary and unfair governmental actions. Now, those things are stated in the Fifth Amendment. The 14th Amendment just makes that active in the states. It means the states have to abide by it. All right, so what is due process? We're going to talk about substantive and procedural again, okay? Remember, substantive is everything inside of it, what it means. Procedural is what we do to get to that point. Now, substantive due process refers to protection of fundamental rights from government interference. This ensures our laws and government actions are fair and just. In testing, we use tests to make sure those actions are compatible with our liberties that were given by the Constitution. The procedural side of it looks at making sure the process is fair and impartial in government procedures when it's depriving an individual of life, liberty, or property. It ensures adequate notice and opportunity to be heard. So one is that the law itself and everything that goes into it, all those pieces of tests we would do, those type of things, that they are fair, they work, and they're compatible with our liberties. Procedural means that that process we take to get to that point, that it is, we're given adequate notice, the other party has a chance to be heard, and that everything is fair and impartial that we're doing. All right, so now we're at the test. Promised you a few slides ago, we finally made it there. All right, equal protection. The Equal Protection Clause mandates that individuals in similar situations be treated similarly by the government. It aims to prevent discriminatory practices by the state. So if we're both arrested and the law states that we should be treated, equal protection means we are treated the same, given the same rights, afforded the same opportunities, giving the same charges or the same types of deals, all things being the same prior to the arrest, the crime being the same, then everything should be the same after it. We do that by looking at certain tests. I know it's not all about arrest. It's about that we're being protected, given equal protection under the Constitution and laws that we abide by. Once again, we have the rational relationship test, strict scrutiny test, and intermediate test. It would be a good idea to know these and be able to recognize these on site. I do know that you will see these on quizzes and on the midterm. I'll tell you, you'll see these, and you may see them more than once on these tests because a lot of what we've said up to this point is tied into these and how they make sure that everyone is treated fair. So the first one, the rational relationship test, is used to evaluate a law. Does the law, if the law is related to economic regulation, is there a legitimate government interest that it's related to? All right, what is the governmental interest that this law that is creating this economic regulation that it is tied to? So if someone was to try to sue because of income tax being taken out of their check, and believe it or not, people have tried to do this several times, hundreds of times, thousands of times, and it never works out. But they were trying to sue. The basis for the test, does it line up with a rationally related issue of legitimate government interest? And yes, those taxes go to pay for infrastructure, go to pay for health care, go to pay for several things that are used for along with paying salaries and stuff of other people. But the taxes we pay in go to all the things that are meant to make our life easier as citizens. All right, smoother roads to drive on, better systems to get in contact with the government, a more accurate count of votes, a more accurate decision on our taxes, those type of things. All right, so those are legitimate government interests. They provide for a bigger or broader leeway for economic and social policies. They allow for growth in that. The next one down is going to be the strict scrutiny test. The strict scrutiny test is applied to the regulations that affect fundamental rights or involve suspect classifications such as race or national origin. If you think about the different classifications of people, when we consider what discrimination is, we have, certain things in certain classes that are discriminated against. Someone who is over the age of 40 can be discriminated against when it comes to age, when they're being considered for a position or promotion or things along those lines. Strict scrutiny test says if we have a fundamental right that's being affected, or we think there's something involving a special classification that is suspect, then the government must show that the regulation is necessary to achieve a compelling interest. Compelling interest, read that as keep the government running. All right, there has to be something in here that says we're doing this to protect citizens. We're doing this to keep the government running. We're doing this to make sure that we're not being invaded and taken over by a foreign country. We're doing this to make sure that our elections are going the way they should go. Our democratic process is working the way it should. Those are things that strict scrutiny tests would look at. A regulation is necessary to achieve compelling interest and is narrowly tailored to meet that interest. So it can't be something that's broad in what it does. It has to be tailored down to meet a certain interest. If it's an interest of national security, it can be something as simple as not allowing the publication of well locations in rural settings. If you live out in a rural area, you most likely do not have city water. You don't have municipalities. You have a well that is drilled down in the ground up under your property and water comes out of it. Well, that is protected and as a national security issue. You cannot, through the Freedom of Information Act, request where that well or well locations in an area because of that, because of Saturday morning cartoons. And this is how I always do this. On the Saturday morning cartoons when I was younger, the bad guys always wanted to poison the water system. They wanted to keep people from being able to drink the water. You shut people's water off. You start to destroy civilization, those type of things. Well, that's true. Okay. So someone does that, they know where the wells are, they could begin to poison the water system. So that's information that's protected. All right. The strict scrutiny test said, well, if for some reason we needed to affect this in some way, there has to be a legitimate reason that is a national interest or compelling interest, and it has to specifically fit that issue. Intermediate test, not quite as strict. It's applied to laws involving gender or legitimacy, requiring that the law be substantially related to an important government interest, and offering a balance between strict scrutiny and rational bias. Intermediate is kind of the middle ground there, making sure that we're still meeting the interest of the government, that it's still there, and we have some balance between it. All right, so that finishes up. Told you it wasn't a real long one. I'm going to go ahead and stop.